In this lecture, we would like to discuss another important doctrine, that is the doctrine of occupied field, and that very doctrine explained about legislation in between the union and the state and their respective powers. So, the very doctrine of occupied field is a legal principle in constitutional law that deals with the distribution of powers to the government at different levels within a federal system. It essentially means that if a particular subject matter or field is exclusively occupied by the legislation at one level of government, either the central or the union or the state, then the other level of government cannot legislate on the same subject matter. This doctrine helps avoid conflicts and overlaps in legislative authority. So, regarding that, we'll discuss the provisions of Article 254 of the Constitution regarding the concurrent list. So, Article 254 of the Constitution of India states the provisions and measures regarding inconsistency between laws made by Parliament and laws made by the state legislatures. Article 254 addresses the relationship between union and state laws on concurrent list subjects by providing a framework for resolving conflicts by giving precedence to union laws if they have received the president's approval. This aligns with the concept of Indian federalism in the very doctrine. So, Article 254 of the Constitution of India deals with the concept of inconsistency between laws made by the central government and the laws made by the state governments on matters that are in the concurrent list, which is the third list of the seventh schedule of the Constitution. So, Article 254 of the Indian Constitution addresses what happens when there is a conflict between laws occupied by the national government and those made by the state governments on certain topics that both levels of government have the authority to legislate as provided under concurrent list or the third list of the seventh schedule of the Constitution. In simple terms, when there is a disagreement between a law passed by the national or central government and a law passed by a state government, and both laws are related to subjects listed in the concurrent list of the Constitution, the national law usually prevails. The doctrine of occupied field provides that if an act of the Parliament occupies a subject over which the state legislature is also empowered to legislate and has also legislated, and the state legislation obstructs the operation of the Parliament's Act, then the state's legislation is inconsistent with the Parliament's Act to the extent of the provision or provisions which obstruct the latter's operation. So, now we'll discuss the very concept of federalism in India in relation to the very position of doctrine of occupied field. So, federalism is a system of government in which the powers are divided between a central government and smaller political units, which are otherwise called as states. The concept of federalism is often used to strike a balance between strong centralized authority and regional autonomy or self governance. This concept has been adopted by many countries around the world, and one of them is India. But in the context of India, the very concept of federalism, as per the very distribution of power between the center and state, it got a name, that is quasi-federal system. And now we'll go to the very legislative relation between the union and states as provided under the Constitution of India under Article 245 to Article 255. In India, the legislative relation between the center or the union, the national or federal government, and the states, the regional or provincial governments are governed by the principles of federalism as enshrined in the Constitution of India. There are legislative relations between the state and the central government, and the doctrine of occupied field helps in maintaining a division between the law-making powers of the state and the center. The very legislative framework in India, as we found, is provided under Articles 245 to 255 of the Indian Constitution, which deals with the distribution of legislative powers between the union and the states, as well as the framework related to resolving disputes related to these powers. So, now we will go to 7th schedule of the Constitution, where we found union list, state list, concurrent list, and among these the first one is list 1, the second one is list 2, and the concurrent list is otherwise called as list 3rd. So, the 7th schedule of Indian Constitution enumerates the division of powers and responsibilities between the union and state. The 7th schedule has 3 lists, namely the union list, the state list, and the concurrent list, that shows the division or distribution of powers regarding legislation between the union and states concerning certain subjects or items enumerated in those lists. The union list has a total of 97 items or subjects, while the state list has 66 subjects or items and the concurrent list has 47 items or subjects as enumerated under the 7th schedule of the Constitution. And now we'll discuss certain exact provisions under Union list. We found there are 97 subjects or items numbered as provided in 7th schedule to the Constitution of India. The Union Government or Parliament of India has exclusive power to legislate on matters relating to these items. The doctrine of occupied field is found in entry 52 and entry 7 of the Union list, and that is list number 1, while the state list is a list of 66 subjects or items in the 7th schedule of the Constitution of India. The respective state governments have exclusive power to legislate on matters relating to these items, and exclusively entry 24 or the item or subjects mentioned in state list or list 2. And now we'll discuss certain important provisions or items under concurrent list. There are 47 items currently on the concurrent list, including items that are under the joint domain of the Union as well as the respective states. However, once the Parliament makes any law on the subject of concurrent list, then the state legislature, assemblies or legislature cannot make any law on that particular subject. It basically excludes the legislative jurisdiction of the state legislative assemblies. And now we'll go to the very scope and application or the now we'll discuss in respect to the power of Parliament to legislate on state subjects. So the very subjects as provided, the very scope and application and regard to that in India, Parliament has the power to legislate on subjects that fall within the state list, and that is list 2 under specific circumstances as provided for in the Indian Constitution. And this is known as the power of Parliament to legislate on state subjects, and it is outlined in Article 249 and 250 of the Constitution. So now we'll discuss Article 249 and Article 250. So Article 249 of the Constitution of India provides a mechanism for the Parliament of India to legislate on subjects that are typically under the jurisdiction of individual states. In simpler terms, it allows the central government to make law on certain matters that usually fall within the authority of state government. So Article 249 provides that the Indian Parliament to create laws on specific topic, and exactly how this happens, that when the Council of States or the upper house of parliament or the Rajya Sabha passes a resolution by a two-thirds majority stating that it is necessary for the national interest to have a uniform law on a particular subject, one such resolution is approved. Parliament can make laws on this subject, and these laws will be binding on all states, overriding any conflicting state laws. This provision helps maintain consistency and address issues that requires a nationwide approach. Basically, the very purpose of this Article 249, that to legislate in national interest, and Article 250 of the Constitution empowers the Parliament to make laws on matters listed in the list. If the Rajya Sabha, the upper house of Parliament, passes a resolution by two-thirds majority, that is, it is necessary to do so in national interest. In simple terms, it allows the central government to legislate on subjects which are typically under the authority of the state governments. So it allows the central government to create laws related to topics that are usually the responsibility of the state government. However, there is a condition: this can only happen if the Rajya Sabha agrees to a two-third majority votes. So, exactly, national interest in general means interest of the nation or country as a whole, not individually or as an individual or group. Governments make decisions and make policies all for the national interest. So, in this regard, we are to discuss the very scope and application. So, the very doctrine of occupied fields is found in entry 52, list 1, that is the union list, and entry 24, that is the state list or list 2, which when read together state that the parliament can make laws to exercise control over certain industries in public interest, which would render those industries out of the legislative power of the state legislatures. Further, entry 7, list 1 or union list provides that the parliament has the competence to legislate over industries necessary in relation to the defense or prosecution of war. The doctrine provides a basis for the parliament to legislate on matters related to mines and minerals, higher education, regulation of foods, etc. So the very scope and its application of the doctrine of occupied field first is in the field of education. So it is primarily a subject within the domain of state government, but the central government can also legislate on certain aspects of education, but it cannot encroach on the fields occupied by the state. And now we'll go to the second field, and that is healthcare. So, in this scope and application of the doctrine, it is primarily a state subject, and it is the duty of the state to take responsibility of the different aspects related to healthcare, However, the central government can make laws relating to healthcare. And now we'll go to the third field, that is public order. Maintenance of public order has been listed in the state list of the Constitution of India, while the central government can provide assistance to the state in matters relating to state government. And the fourth area or field is agriculture. Agriculture is mainly a state subject, and the state government has the authority to make and amend laws on matters relating to agriculture, land, and irrigation. However, the central government also made laws on the same matter, but it should make sure to not encroach on the fields occupied by the state. So, now we'll discuss certain important essentials of this very doctrine of occupied field. So, the very doctrine of occupied field, in the essentials we found one is enumerated powers. So, the Constitution must specify and distinguish the powers and responsibility of each level of both the state and central government in the absence of a specific distribution of powers. The doctrine may not apply. And now we'll go to exclusive legislation. And in that connection, the doctrine comes into play when a particular field or subject matter falls within the exclusive legislative competence of one level of government, which means that the other level of government cannot legislate on that subject matter. And lastly, we'll go to the third one, the very intent of the Constitution. The doctrine is often based on the intent of the Constitution. If it is clear that the Constitution intended for one level of government to have a exclusive authority over a particular field, the doctrine applies. It means that if the Constitution empowers either the central or the state government to make laws in a particular field, and the other government tries to interfere in making laws in that particular field, the doctrine of occupied field applies. And now we'll discuss certain importance of this doctrine and the very importance that we found regarding this very doctrine of occupied field is the first one, protecting the legislative intent. The doctrine helps in protecting the interest of legislature by clearly establishing separate powers for the union and the state government so that they don't overlap each other's powers and also do not interfere with each other's subject matters. And the second importance, that is balancing the interest between parliament and state legislative assembly. It helps balance the interest of parliament and state assemblies by striking a balance between the powers of the government of both levels by clearly establishing separate powers for the union and the state government so that they don't interfere with each other's interests and powers. The doctrine helps balance the interest between the parliament and the state legislative assemblies. And now we'll go to the third importance, that is it avoiding conflict. So it helps prevent conflicts and legal disputes between different levels of government by clearly stating their areas of legislative authority. And now we'll discuss efficiency, which is another importance of the very doctrine of occupied field. By assigning exclusive authority over certain subject matters, it ensures that one level of government can efficiently legislate and regulate in those areas without interference from the government at another level. And now we'll go to the fifth importance of this doctrine of occupied field is clarity. So it provides basic clarity and predictability in the legal framework for the government, making it easier for citizens and businesses to understand and comply with laws at both levels. And now we'll discuss those important leading cases relating to the very doctrine of occupied field. So the first important landmark judgment, that is State of Bombay versus United Motors India Limited in 1953, Supreme Court expressed and observed in this particular leading case. The respondent was involved in selling motor vehicles in the state of Bombay, which is now the state of Maharashtra. The state government imposed a tax on the sale of motor vehicles, arguing it was distinct from the central government's taxation on the sale of goods. The central issue was whether the state's tax conflict with the central government's power to tax the sale of goods under the Central Sales Act 1956, leading to dispute over the occupied field of doctrine. So, the issue raised in this case is that the central issue before the court was whether the state government had the power to levy a tax on the sale of motor vehicles, and if so, whether it conflicts with the central government's power to tax sale of goods under the Central Sale Tax Act 1956. So the very judgment delivered by the Supreme Court that the field of taxation on the sale of goods was occupied by the central government, and thus imposing a tax on the sale of goods by the state government was declared unconstitutional. And now we'll go to discuss another most important landmark judgment is S.R. Bomai versus Union of India in 1994. The very fact of the case is that central government dissolved the state government in Karnataka, alleging a constitutional breakdown of the machinery of the government. The dismissal was done under Article 356 of the Constitution of India. According to the provisions of Article 356 of the Constitution, the President, on the basis of a report from the Governor of a state, can promulgate a constitutional emergency if he is satisfied that the administration of the state cannot be carried on in accordance with constitutional provisions. After that, President may assume all or any of the functions of the state government, which can be termed a constitutional breakdown of the machinery of the state. So the very issue raised in this important leading case, whether the imposition of president's rule on the basis of alleged constitutional breakdown is justified, whether the court could review the president's rule. So the judgment, as it was held by Supreme Court, that the president's rule could be judicially reviewed and should not be imposed in cases of constitutional breakdown. The court affirmed that the imposition of the president's rule is subject to judicial review because it involves a potential violation of the basic structure and principles of Indian Constitution. The court recognized that the power to impose president's rule was not absolute. It could not be exercised arbitrarily or for political reasons. Instead, it could only be invoked in situations where the constitutional machinery in a state had broken down. And now we'll go to the third important leading case, and that is TM Pai Foundation versus State of Karnataka in 2002, that exactly deals with the very facts of this case that we would like to discuss. The regulation of admission and fees at private unaided universities was questioned. The TMAPI Foundation was an organization that ran several educational institutions like engineering colleges, medical colleges in the state of Karnataka. The state of Karnataka had enacted the Karnataka Professional Colleges Regulation of Admission and Determination of Fees Act 2000, which sought to regulate the admission process and fees structure in private professional colleges, including those run by trust like the TMA5 Foundation. So the Act established a regulatory authority that had the power to oversee admissions, fees fixation, and other aspects of private professional colleges, which was challenged by the plaintiff on the ground that it violates the autonomy of college and violates the fundamental right under Article 19, Clause 1, Subclause G, and Article 26 of the Constitution. So the issue raised whether the state government has the authority to regulate admission in private unaided colleges. If so, does it violate the autonomy of colleges? It was held by Supreme Court that education is primarily a state subject and the state government can regulate admission in unaided colleges, but while doing so, it should keep in mind that it should not affect the authority of any such institution. And now we will discuss the very differences that we found in between doctrine of occupied field and doctrine of repugnancy. So, first is the difference regarding nature, the second one is regarding scope, and the third one, the difference regarding their application, and the fourth one regarding constitutional basis, and the fifth one regarding purpose, the sixth one. Some examples to differentiate these two. So, in that connection, we will discuss as regarding doctrine of occupied field. In regards to its nature, it deals with the exclusive legislative competency of one level of government on a specific subject matter, as while under doctrine of repugnancy, it addresses conflicts between federal and state laws on the same subject matter, and as regarding to scope, doctrine of occupied field operates within the framework of enumerated powers and the exclusive authority of one level of government, as while in connection to doctrine of repugnancy, it focuses on the inconsistency or conflict between specific federal and state laws. And as regarding the very difference on the basis of application of the doctrine of occupied field, it prevents the other level of government from legislating in the field already occupied by another level of government. But in regarding to doctrine of repugnancy, it resolves conflicts when both level of government have legislated on the same subject. And now we'll go to the very constitutional basis regarding both the doctrine. So, as regarding doctrine of occupied field, it is based on the division of powers specified in the Constitution, as we found in India under Union list, state list, and concurrent list. But regarding doctrine of repugnancy, it is based on the principle of federal supremacy. And now we'll go to the very purpose of both the doctrines. As regarding the doctrine of occupied field, it aims to avoid legislative duplication and conflicts by specifying exclusive legislative competence. And as regarding doctrine of repugnancy, it aims to resolve conflicts that arise due to inconsistency or contradictory laws enacted by different levels of government. And last one that we found in between doctrine of occupied field and doctrine of repugnancy, that is those examples as regarding doctrine of occupied field, matters related to foreign affairs, national defense, and currency are typically occupied by the central government, and that is the government of India. As regarding doctrine of repugnancy, if a state law seeks to regulate a subject that is already governed by a federal law, and there is an inconsistency between the two, the doctrine of repugnancy comes into play. So the doctrine of occupied field deals with the exclusive legislative competence, while the doctrine of repugnancy addresses conflicts between federal and state laws. Both doctrines are crucial to maintaining the integrity and harmony of a federal system by providing a framework to resolve conflicts and allocate legislative powers. And now we'll discuss the very conclusion regarding the doctrine. And as regarding the very doctrine, the conclusion, the efficiency that we found in regards to the doctrine of occupied field, that it exactly provides that the doctrine occupies an important field, and that is relating to state laws or the state government laws that were enacted by the state legislative assemblies. So, in conclusion, we can say that doctrine of occupied fields and doctrine of repugnancy play crucial roles in federal systems. Both doctrines operates in different contexts. The doctrine of occupied field focuses on delineating between exclusive legislative competence, while the doctrine of repugnancy addresses conflict between laws enacted by different labels of government, upholding the principle of federal supremacy and ensuring uniformity and consistency in laws across the nation. The doctrine of occupied field is a legal principle in constitutional law that deals with the distribution of power to governments at different levels within a federal system. The doctrine of repugnancy is a simple doctrine used to check the validity of state laws with obligation to federal laws. These doctrines are important to maintain the flow of power between the governments at different levels and to avoid conflict at any level of legislation. So, the very Constitution of India, as provided under 7th Schedule of the Constitution, distributed and divided powers between the Union and State as under List 1, which is Union list, and List 2, which is a State list. And besides that, it provided a third list, that is the concurrent list. So these three lists list under the 7th schedule distributed and allocate legislative power to respective level of governments and respective level of legislative authorities like the central legislative authority, the Union Parliament, and the state legislative authorities like the state legislative assemblies, only to allocate such powers. And as already it is being provided and under the Constitution, and it is specifically and categorically as mentioned under the Constitution. So, one level of the government could not encroach on the other level of government for making any law, and that basically as provided under a federal system by distribution of legislative powers in between the union and the state. For that very purpose, the doctrine of occupied field got the relevance and importance in constitutional law, and in particular in the constitutional law of India. So, in this particular lecture, we have finished in detail the very doctrine of occupied field as with reference to the provisions of Article 254 of the Constitution of India and the very legislative powers provided both to the state and the union as under Article 245 to 255 of the Constitution of India, and in respectively to certain important occurrence such as under Article 249 in regards to national interest, and as under regarding Article 240, 250 in relation to legislation on state items or subjects during emergency, how the Parliament of India have substantial powers to legislate. So we have discussed certain important, relevant landmark judgments such as the State of Bombay versus United Motors India Limited in 1953, and also S.R. Bommai versus Union of India in 1994, also TMA5 Foundation versus State of Karnataka in 2002. So these are the relevant and important judgments relating to the very doctrine of occupied field.